Three justices looked at that ruling and said no. Three people sitting on the highest court in the land, the final word on American law, American rights, American life, looked at what their colleagues were about to do and said, this is wrong. And the rest of them did it anyway. That is where we are right now. That is the moment we are living in. The Supreme Court of the United States just issued an emergency decision that is shaking the foundation of this country. And if you haven't heard the full story, if you've only caught the headline and moved on, then you do not yet understand what has just happened to you, to your family, and to every person living under this flag. We're talking about the three justices who said no inside the emergency Supreme Court decision shaking the nation. This is not background noise. This is not partisan politics as usual. This is a rupture. And you need to understand exactly what it means before we go any further. If you care about real journalism, about someone who will sit here and tell you the truth without flinching, without corporate pressure, without spin, hit that subscribe button right now and turn on notifications. Because the stories that matter most are the ones the comfortable don't want told, and we're going to keep telling them. What actually happened? The emergency decision explained. Let's be precise about what an emergency Supreme Court ruling actually is, because the term gets thrown around and people's eyes glaze over, and that's exactly what the powerful are counting on. An emergency application to the Supreme Court, what lawyers call a shadow docket decision, is not a standard case. It does not go through the normal appellate process. There are no months of briefings, no oral arguments where both sides get to stand up and make their case before the American public, no slow, deliberate march through the judiciary. An emergency ruling is fast. It is powerful, and it is by its very nature less transparent than almost anything else the court does. When the Supreme Court acts on an emergency basis, it means something could not wait. It means someone, a government, a party, a set of powerful interests convinced at least 5 justices that the situation on the ground was so urgent, so irreversible, that normal legal process had to be bypassed. That is an enormous amount of power concentrated into an extremely short window of time. And in 2026, this court used that power in a way that has sent shockwaves through legal communities, through civil rights organizations, through ordinary households, and through the chambers of anyone who still believes that the judiciary exists to protect people, not to serve the powerful. The specifics of what triggered this emergency matter enormously. A lower court had issued a ruling that provided protection, that said a particular action by the federal government was unlawful, that said certain rights or procedures had to be honored before the executive branch could act, and the government didn't like that ruling. So rather than wait for the standard appeals process to play out, rather than let the legal argument breathe and develop in the way our system was designed to allow, the administration went directly to the Supreme Court and said, stop this, freeze it, override the lower court right now, and a majority of justices said yes. Think about that sequence. A court below a federal judge applying the law said the government cannot do this, and the Supreme Court on an emergency basis said yes it can, no full briefing, no oral argument, no public deliberation, just 5 justices in agreement, and the lower court's protective order is gone. Whatever protection existed, whatever legal firewall stood between government power and the people affected, evaporated. And the consequences didn't wait for a proper ruling. They began immediately, because that is the nature of emergency action. And by the time the full legal argument plays out, the harm may already be done. The people affected may already have suffered what the lower court was trying to prevent. That is not a technical, legal concern. That is a human concern. Those are real people. And 3 justices, 3 members of this court, wrote that this was wrong. They put their names on dissents that, if you read them carefully, read less like legal arguments and more like warnings. Warnings to the public, warnings to history, warnings about what kind of institution the Supreme Court is becoming and what kind of country we are building in 2026. Who are the 3 justices who dissented and why it matters? The 3 justices who said no are not dissenters in the theatrical sense. They are not grandstanding. They are not performing for cable news. When a Supreme Court justice writes a dissent, especially in an emergency ruling where time is compressed and the pressure is immense, they are doing something that requires both legal courage and a certain kind of moral clarity. They are saying, on the record, for all of history to read, I think this is wrong. I think my colleagues are making a mistake. And I think the people of this country deserve to know that someone on this court sees what is happening. What the dissenting justices argued, and this is critical, is not simply that they disagreed with the outcome. That would be ordinary legal disagreement, the kind that happens every day in courts across this country. What they argued is that the process itself was broken, that using emergency procedures to override a protective lower court ruling without full briefing, without adequate time for the affected parties to even respond properly, without the transparency that Americans are owed when their rights are being decided, is an abuse of the shadow docket, that it transforms the highest court in the land from a deliberate, principled institution into an instrument of speed and executive power. One of the dissenting justices wrote something that should be printed on the front page of every newspaper in this country. And the substance of what they said, and I want you to hear this clearly, is that when the court acts this quickly, this opaquely in cases with this much consequence, it is not upholding the law, it is making law without argument, without accountability, without the American people even fully understanding what just happened until the damage is done. And that is not a liberal concern or a conservative concern. That is an American concern. That is a concern about power and who holds it and whether anyone can check it. The three justices who dissented understand something that the majority apparently does not or does not care about. They understand that the legitimacy of the Supreme Court is not automatic. It is not guaranteed by the building, by the robes, by the lifetime appointments. It is earned over time through process and transparency and the demonstrated commitment to treating every American rich or poor, powerful or vulnerable, the same under the law. And when the court abandons that commitment, even once, even in the name of urgency, it chips away at the foundation that holds the whole structure up. Those three justices were not just dissenting from a ruling, they were sounding an alarm about the institution itself. And here is what makes their dissent even more significant. They were not surprised. Anyone who has been watching this court, watching the explosion of shadow docket use over the past several years, watching emergency applications become a tool of political strategy rather than genuine legal emergency, knew that this moment was coming. The three dissenting justices have seen it building. They have written about it. They have warned about it. And now it has arrived at a level of consequence that cannot be minimized or explained away. The question is whether the rest of us were paying attention to the ruling's real-world impact on ordinary Americans. Here's where we stop talking about procedure and start talking about people. Because if a Supreme Court ruling doesn't connect back to flesh and blood human beings, to the woman trying to navigate a federal system that just changed overnight, to the family whose legal status shifted without warning, to the worker whose protections evaporated because 5 justices moved faster than the public could follow, then it is just noise. And this is not noise. The people most immediately affected by this ruling are not the lawyers arguing the case. They are not the politicians issuing statements. They are ordinary Americans who woke up one morning to find that the legal protection a federal judge had granted them no longer existed, that the things standing between them and a government action they feared had been removed by a court they never got to speak to, in a process they never got to participate in, based on arguments they never got to hear. That is not the American justice system working as intended. That is the American justice system being used as a weapon against its own people. Depending on the specific subject matter of this ruling, and emergency decisions in 2026 have touched everything from immigration enforcement to federal agency authority to the rights of individuals caught in bureaucratic crossfire. The human consequences are not abstract. They are immediate. They are families separated. They are people detained. They are individuals stripped of access to programs, protections, and legal remedies they were counting on. They are communities that organized, that fought through proper legal channels, that won in a lower court, and then watched that win get snatched away in the middle of the night by a court operating in the shadows of. And here is the deeper insult. Many of these people have no realistic recourse. The emergency nature of the ruling means the harm happens now. The full legal process, the briefings, the arguments, the eventual written opinion with full reasoning comes later. But later is often too late. Deportations cannot always be undone. Lost jobs don't automatically come back. Missed deadlines, broken families, ruined plans. These don't wait for the Supreme Court to eventually issue its full opinion 6 months down the road. The damage is done in real time to real people. And the system designed to protect them just made it worse. What should disturb every American, regardless of where you fall politically, is the precedent this sets. Because if the Supreme Court can be used as an emergency tool to override lower court protections on the timeline of the executive branch's choosing, then the protection of any right, any person, any community becomes conditional on whether 5 justices can be convinced to move fast enough in the right direction. That is not the rule of law. That is the rule of whoever can access the court the quickest with the most sympathetic argument, and history tells us with painful clarity who that tends to benefit. It is not the poor. It is not the vulnerable. It is not the person with no legal team and no political connections. It never is. The institutional crisis behind the curtain. To understand this moment fully, you have to understand how we got here, because nothing about this is accidental. The Supreme Court's increasing reliance on shadow docket emergency rulings is not a bug in the system. For certain political actors, it is a feature. It is a way to achieve legal outcomes without the scrutiny, the delay, or the democratic friction that comes with normal judicial process. And the people who engineered the current composition of this court knew exactly what they were doing over the past decade, and accelerating dramatically in the years since. The federal judiciary has been reshaped with surgical precision, not just the Supreme Court, but the circuit courts, the district courts. Every level of the federal bench, judges were confirmed at record pace, with reduced scrutiny, in a deliberate strategy to lock in a particular legal philosophy for a generation. That is not a secret. The people who did it said so openly. They were proud of it. And now, in 2026, we are living with the consequences of a judiciary that was built not to be independent, but to be aligned with a particular vision of executive power, of federal authority, of who the law is supposed to serve. The shadow docket is the clearest expression of that alignment. Emergency applications to the Supreme Court used to be rare. They were reserved for genuine crises, situations where irreparable harm was so immediate and so obvious that waiting for normal process was genuinely impossible. Now they are a routine tool. Administrations of both parties have used them, but the current acceleration, the willingness to go to the court on an emergency basis, to override protective lower court rulings, to freeze injunctions, to remove legal shields from vulnerable populations, represents something qualitatively different. It represents a court that has made itself available as an instrument of executive speed rather than a check on executive power. And the 3 justices who dissented in this ruling have been raising this alarm for years. They have written separately, repeatedly, in case after case, saying that the shadow docket is being abused, that emergency standards are being loosened to the point of meaninglessness, that the court is making law significant, consequential, lasting law without the process that gives that law legitimacy. They have been largely ignored by the majority. And more importantly, they have been largely ignored by the media, which found the procedural complaints too dry, too technical, too inside baseball to explain to the American public in the urgent terms that would have made people pay attention before we reach this point. The institutional crisis is not just about this one ruling. It is about a court that has lost the ability to police itself, that has no meaningful ethics enforcement, that operates with less transparency than almost any other major democratic institution in the world, and that has watched its public approval collapse to historic lows without any apparent concern that those approval numbers might be telling it something important about whether it is doing its job. A court that the public does not trust cannot serve the function a court is supposed to serve. And yet here we are. What the media and political class got wrong. If you want to understand why this emergency ruling caught so many Americans off guard, why people are only now realizing the magnitude of what happened, you have to look at the media coverage and the political response, because both failed the public in ways that need to be named directly and without apology. The media, and I say this as someone who believes in journalism deeply enough to keep doing it, covered this story the way it covers most Supreme Court news, as a political scoreboard. Who won? Who lost? Which side is celebrating? Which side is angry? The legal substance, the procedural concerns, the shadow docket critique that 3 justices put on the record in their dissents that got buried. It got turned into a paragraph at the bottom of an article that most readers never reached. It got translated into partisan framing that made it easy for half the country to dismiss it as just the losing side complaining. And in doing so, the media failed at its most basic function, which is to tell people what is actually happening and why it matters to their lives. The shadow docket is not a sexy story. Emergency procedures are not clickbait. And so the coverage defaults to the outcome, the ruling, the reaction, the political implications for the next election, rather than the process, the precedent, and the long-term structural damage being done to an institution that millions of Americans still believe in and rely on. That is a failure of journalism, and it has consequences. The political class did not do better. Politicians on the side that benefited from this ruling celebrated it as a win without once acknowledging the procedural concern, without once saying, yes, we got the outcome we wanted. But the way this court is operating should concern every American, regardless of the result. That kind of intellectual honesty is almost non-existent in 2026, and politicians on the losing side, the ones who should be screaming about the shadow docket, who should be using every platform and every microphone to explain to ordinary Americans what is being done to their judicial system, issued careful statements written by lawyers that generated exactly zero public outrage because they were designed not to offend anyone. Nobody in the political mainstream is saying clearly what the three dissenting justices are saying in their written opinions. Nobody is translating it into plain English and putting it in front of the people who need to hear it. That is a vacuum. And vacuums get filled by misinformation, by cynicism, by the exhausted and correct conclusion of millions of Americans that the system is broken and nobody in charge is going to fix it. The outrage exists. The awareness barely does. And that gap is not an accident. It is a product of a media and political culture that has decided the details are too complicated and the audience is too distracted. That is condescension dressed up as pragmatism. If you're still watching, still reading, still trying to understand what is actually happening in this country, that matters. That matters more than any individual ruling, because an informed public is the only real check on any of this. Subscribe if you haven't already. Share this with someone who needs to hear it. The conversation has to get louder than the silence they're counting on. Where do we go from here? The stakes for American democracy. So where does that leave us? What does an American do with this information, with the knowledge that the Supreme Court issued an emergency ruling with massive real-world consequences, that 3 justices said on the record that it was wrong, that the media and political class failed to explain it, and that the people most affected had the least power to stop it? First, let's be honest about the stakes, because sugarcoating them doesn't serve anyone. The shadow docket problem is not going to solve itself. The institutional erosion of the Supreme Court is not going to reverse, because enough people feel bad about it. The precedent set by this emergency ruling will be cited in the next emergency application and the one after that, and the cycle will continue. Unless something changes. And what changes things, historically, in a democracy is not the goodwill of the powerful. It is organized, informed, relentless civic pressure from the people who are supposed to be the ultimate authority in this country, which is all of us. That means understanding what Congress can actually do, because Congress has more authority over the structure of the federal judiciary than most Americans realize. It can expand the court. It can impose ethics requirements with the force of law. It can regulate the shadow docket through legislation that sets clearer standards for when emergency applications can be granted. None of these things are easy. None of them are fast, but they are real levers of power that exist in the democratic system. And the reason they haven't been pulled is not that they can't be. It is that the political will has not been forced into existence by sufficient public demand. And that is on us. That is on every American who reads a headline about the Supreme Court and sighs and moves on. That is on every voter who decides that judicial appointments are not the issue that drives their choice at the ballot box, despite the fact that the federal bench shapes every aspect of American life in ways that no election cycle can easily undo. The 3 justices who dissented from this ruling are doing their part. They are creating a public record, making an argument, putting a marker in history that says at least some members of this court understood what was happening. But a written dissent is not a remedy. It is a document. The remedy has to come from somewhere else. The remedy comes from demanding that your senators treat judicial nominations with the gravity they deserve, not as a game of procedural one-upmanship, but as the most consequential decisions they make, because they are. The remedy comes from supporting the organizations doing the legal work on the ground, the ones who brought the case to the lower court in the first place, who won there, who are now scrambling to respond to an emergency override from a court that didn't give them adequate time to argue their case. The remedy comes from refusing to accept the framing that says this is too complicated for ordinary people to understand, because it is not. If you've made it this far, if you've been following this story, you understand it. And you understand it well enough to talk about it, to vote on it, and to refuse to let the people who benefit from your confusion keep confusing you. The 3 justices who said no in this emergency ruling are not heroes. They are people doing their job, doing it honestly, doing it with integrity, doing it in the face of a majority that has different priorities. But in 2026, in a court and a political culture where honesty and integrity are increasingly optional for the powerful, doing your job right stands out. Their dissents are a record of this moment, a record of who saw what was happening and said so. The question that history will ask, and that we should start asking right now, is what the rest of us did about it. Because it is not enough to be angry. It is not enough to shake your head and feel righteous and move on to the next outrage. This country is not going to be preserved by the people who always knew it was going wrong. It is going to be preserved, if it is going to be preserved, by the people who found out what was happening, got loud about it, and refused to let the machine grind forward without resistance. The three justices who said no made their resistance part of the permanent record. Now it's your turn. If this conversation mattered to you, if you believe that journalism that explains power and tells the truth without flinching deserves to survive, subscribe, comment, and share this right now. Tell someone what you just learned. Start the argument at the dinner table. Make someone uncomfortable with the truth. That is how change begins. Not with a ruling, not with a dissent, with people who know what's happening and refuse to pretend otherwise. We'll keep doing this work as long as you keep showing up for it. Don't stop now.